here's where the critical aspect comes in, Aman. Remember, when the victim sought in 2019 the CBI support and the fact that Sengar be tried under more stringent provisions of a public servant being accused of rape, that point, the CBI refused to back him. Now, with this observation coming in, can we expect more serious charges under POCSO?
Well, see, Akanksha, certainly the revelations we made through the Sengar files, the two-part installment series that we did, it clearly showed that CBI could have helped the victim more. In the trial court in 2019, the victim went to the trial court saying that graver charges under IPC must be put against Mr. Sengar, but the CBI did not support that petition, and that was one ground and that was one issue on which the trial court rejected that particular petition by the victim. And now in the High Court judgment, that particular instance has been recorded where the High Court says that when the victim asked for graver charges, CBI did not support it. Also, the CBI's investigating officer, some grave charges were made against him during the trial court judgment also. The same have been recorded in the High Court judgment also. The victim has gone to the CBI asking for tough action against the investigating officer whom they allege was in total collusion with the victim. Yes, collusion with Mr. Singh rather. And though the CBI did get a conviction in the trial court, what is happening now is in the High Court, those technical flaws which were maybe those things which were not tied up properly are now coming to be questioned by the High Court judgment. The number one thing which has really cost the victim is that the High Court ruled that Mr. Sengar can't be considered a public servant under Section 5C of the POCSO Act. Now the Supreme Court is saying that in such a scenario, a police constable is a public servant under the law, but an MLA is not. And the CBI has gone and told the High Court this also, that yes, maybe in one judgment of the Supreme Court this has been ruled that an MLA can't be a public servant, but you have to undertake purposive construction of the same because this is a POCSO Act with which a minor has been raped. Yes, in the High Court did not listen to that CBI argument, but the Supreme Court seems to be in agreement with the victim and the CBI so far, and that is why the stay has been put on the sentence. It comes with a big relief to the victim because number two, the Sengar will now not be able to come out of jail. He would not have come out for another 2 years, but this particular relief from the High Court was opening the window for him to come out of jail after another 2 years once the sentence, another sentence or 10 years which has been sentenced for the custodial death of the father would have been complete. So the other aspect that we had exposed, that Mr. Sengar got 4 times interim bail in the last 3 years, and then he cited before the High Court that look, at those 4 times there was no threat to the victim. I did not misuse my liberty, and that is what made this High Court note that just because the victim is claiming that she'll be heard, we can't keep Mr. Sengar in jail. So this particular stay by the Supreme Court is also significant in that regard, that Mr. Sengar won't be stepping out of jail neither now, neither after 2 years, depending on what the Supreme Court rules, and that is also a big relief to the victim.
That's why I want